And I have the pleasure to invite now Jeremy Schultz, who is a lawyer in Australia, Finlaysons. That's the law firm Jeremy is working with. And what we became aware, even before we heard about a decision by the Australian Federal Court, was that there are many cases already going on in Australia with regard to climate litigation. And now it's my pleasure to welcome again Jeremy. Jeremy, you're with us, and I'd like to invite you to present us the cases from Australia, the situation in Australia, and of course feel free also to comment on what you've heard so far. Jeremy, the floor is yours.
Thank you, Stefan. I assume you hear me loud and clear, which is a good start.
Yes,
good.
We hear
Thank you.
Well.
That's good. I'd like to thank you for the opportunity to present to you today on this important topic. And we've heard today quite a bit about the German Federal Climate Protection Act case, and I want to comment on that. I think at the outset, I'd like to say that it represents a major step towards worldwide recognition of duties of governments with respect to the impacts of climate change. I will show that whilst its direct application to an Australian setting is limited in Australia, the opportunities for challenge of government inaction in Australia are rapidly growing. So I have some slides, and I'm hopeful now that I'm doing a new share. So I'm going to, this is just me, so you've heard a bit about me, and I don't think you need to know too much more other than I've been in this topic for 20 years and been part of developments with the Clean Energy Council in Australia, and I'm currently the Vice President of the Australian Institute of Energy. What I would like to do is to start with a very quick summary of current developments in Australia that I think are very much relevant to litigation and legal action in the country. In summary, recent developments include coal-based power stations being closed at an increasing rate. As an example, the owner-operator of the Yallourn power station in Victoria has recently announced that it wishes to bring forward the closure of the power station. It's currently scheduled for 2028 and negotiations are proceeding. Wind farms and solar farms are now being coupled with batteries and storage technology so as to assist with what's perceived to be system instability through what is a very long and stringy grid through Australia. Steps are being taken by energy companies and government to develop a hydrogen industry. So I was very interested in the comments from Carsten and Andre in the presentation before me. This is identified as a major development opportunity, both as a domestic production and as a major export opportunity for the country, particularly to countries such as Japan. It's acknowledged that any substantial export industry would need to be undertaken by or underpinned by clean energy generation rather than based on fossil fuels. In what is, for us, an exciting announcement, the Chief Regulator of the Australian electricity system earlier this week approved a major electricity transmission interconnection between the states of New South Wales and South Australia. This is expected to drive the development of a new wave of asynchronous renewable generation. On a negative side, there are new coal mines opening and sought to be opened. And the Australian government has recently announced a 600 megawatt gas generation project to be undertaken. And it's perceived that system security through this Australian stringy grid requires baseload generation as coal generators are phased out. Australian greenhouse gas emissions were reported earlier this week to have fallen 5% from 2019 levels and 20% below 2005 levels. While this may appear pleasing, the question is how much effect did COVID-19 have on these figures? There are no Australian targets with respect to emissions reduction, no federal government targets. There are soft state government targets generally set by way of policy at 50% reduction by 2030. So that's a backdrop of where the system currently sits. We have what I would call minor legislation in this area in the country. There was a Renewable Energy Electricity Act, which requires retailers to acquire a percentage of their electricity from renewable sources. The main environmental legislation is the Environment Protection and Biodiversity Conservation Act, which requires major projects to be examined from the perspective of protecting the environment. I'll reference this in a moment in discussing the Sharma case earlier, which I think is the case that Stefan might have been referring to earlier. There's a Carbon Credits, Carbon Farming Initiative Act, which is based on a fund as the main mechanism to encourage Australian businesses to cut emissions. However, it's perceived on all fronts as being inadequate to reach 2030 obligations under the Paris Agreement. There's also a Reporting Act for big emitters. So I move on, and I think the most important part in the context of today's presentation is twofold. Firstly, the application of the German Federal Climate Change Act decision in Australia, and then secondly, what's happening in addition in terms of litigation. So from a realistic perspective, I would note to start off that the decision is unlikely to apply in Australia. As we have heard, the court found that the precautions specified in the Climate Protection Act were insufficient to prevent an initial lacking response that would necessitate drastic, burdensome action close to the time specified, and that this legislation constituted a contravention of fundamental duties of the state to safeguard the environment and the position for future generations. German decisions are, of course, based on a civil law approach, whereas Australian courts take a common law approach in interpreting the Australian Constitution and other statutes in connection with the Paris Agreement. The common law takes an evolutionary approach rather than a revolutionary approach to the development of the law, and it's based on the doctrine of precedent. The Australian Constitution and other statutes do not specify any duty to protect future generations, in contrast with the environmental duty under the German Basic Law, which I note that, I think it was referenced earlier, that Article 20A of the German Basic Law states very clearly, mindful also of its responsibility towards future generations, the state shall protect the natural basis of life by legislation and in accordance with law and justice, by executive and judicial action, all within the framework of the constitutional order. In Australia, there is no legislation to this effect and no legislation expressly addressing or implementing the Paris Agreement. So there's call it a misfit in terms of applying the German decision. However, the most interesting phenomenon for me at the moment is that despite those factors, there is a clear growing legal accountability for failure to respond to climate change within the courts of Australia. In 2020, Australia had the largest number of proceedings issued after the USA challenging decisions or actions of government in relation to fighting climate change. There are currently 19 cases concerning climate change listed in the Federal Court of Australia. Legislation such as sections 55 and 64 of the Judiciary Act make the executive arm of government subject so far as possible to the same legal liabilities as citizens. Now, the novel duty of care that has been found to exist in very recent times by the Federal Court of Australia in the case of Sharma versus the Minister of Environment is very significant. In short, Sharma and a variety of other underage plaintiffs, a common characteristic in litigation that is emerging, claiming to represent all minors, sought an injunction against the Federal Environment Minister from granting an extension of the Vickery coal mine. The plaintiff argued that coal mining at the scale contemplated by the mine would exacerbate climate change, causing harm to young people into the future. The challenge was made under two sections of the Environment Protection Act that I referred to earlier, and sought to establish that the minister had a duty to take reasonable care to avoid causing personal injury to children when exercising his ministerial discretion in approving the extension of the mine project. Most importantly, the court upheld and established this novel duty of care to avoid causing personal harm to children, which the minister was subject to. It was found that the minister must consider the interests of children when exercising any ministerial discretion in this area. Now, that case wasn't successful on all fronts. An injunction was sought and the injunction was unsuccessful. On the basis of proof, it was difficult to establish that the minister would breach the duty of care. So the challenge is still in front of plaintiffs and, in a sense, the courts to enumerate what factors would constitute a breach of a duty of care. However, it's pivotal that the duty of care was found to exist. There are a couple of others that I wanted to mention briefly before closing. Another interesting mechanism that's been adopted to challenge government occurred in the recent case of McVeigh versus Retail Employees Superannuation Trust. The plaintiff was a contributor to the Retail Superannuation Trust, which owed its beneficiaries information needed to make informed decisions surrounding management of the fund under the Australian Corporations Act. The plaintiff alleged that the trust did not adequately disclose its exposure to climate change risks to its beneficiaries and its strategies to address these risks. Whilst the case was settled, the court acknowledged the public interest nature of the claim in a socially significant issue by issuing an order for the plaintiff's application for maximum costs. Of even more significance, may well be of potential significance, is a claim submitted last year in Kathleen O'Donnell versus the Commonwealth of Australia and others. In this case, 23-year-old law student Kathleen O'Donnell filed a claim in the Federal Court of Australia against the Federal Court and two government officials for allegedly failing to disclose the risks to the value of government bonds posed by climate change. It is understood that this is the first case in the world to deal with climate change as a material risk to sovereign bonds. The decision at this point is pending. The case could potentially be quite momentous, and we're very much looking forward to the decision being handed down. I would mention two other possible claims very briefly. An emerging basis of challenge, human rights was referenced earlier, and that's an emerging basis of challenge in Australia. In the state of Queensland, the recently enacted Human Rights Act is being used to challenge a major proposed coal mine in that state. And the claim alleges that the project breaches a number of rights under the Act, including the right to life, the protection of children, and the right to cultures. And finally, but as interestingly as the other cases I've referred to, is a New Zealand decision last year. New Zealand decisions are based on the common law and have persuasive application in Australia. The recent decision by the New Zealand High Court to hear arguments surrounding a novel inchoate duty to cease contribution to climate change in Smith versus Fonterra Cooperative Group Limited would suggest that there may be a new duty established which could form a substantial new basis of legislation against governments. So, in summary, in the short time available to me today, my conclusions based on consideration of the area is that there are structural limitations in Australia on litigious claims being successful in this area that are not in place in countries such as Germany. However, whilst the common law is normally responsive and not capable of revolutionary change, there is a growing acknowledgement and recognition of new duties in this area, which are very likely to drive litigious action being successfully taken on a significant number of fronts. So we look forward to future developments in this area with interest and with some excitement. So with that, I'd like to hand back to you, Stefan, so that you can, I believe, introduce Janine now. Thank you very much.
Thank you so much, Jeremy, for this really excellent presentation. Not only relating to the German case, I think that was very interesting as well, how that could have an impact or not so much, but also for really kind of opening our eyes, not only in terms of going beyond the German case, but also the opportunities that you see, many different ways how litigation or could find a basis for action, for more climate action. That is indeed very interesting and somehow also very encouraging to see that there are several cases. We hear now from Australia, even from New Zealand. So we've heard now many cases beyond that German case, and that I think that is very good. And I hope that this webinar is also kind of can help to kind of bring together a little bit these approaches. We heard from Dörte there are 900 cases around the world, and that these cases somehow people can learn from each other.